All rise. First District Court of Appeals now in session. All who have business before this court, draw near, give attention, and you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Thank you. Please be seated. Welcome to the First District Court of Appeal. We have two cases on our docket this morning. We'll take them in order. The first case is case number 22-4149, Whitfield versus State. If the appellant's counsel is ready.
My name is Robert Berry. I'm the attorney for Mr. Whitfield.
Mr. Berry, would you like to reserve any time for?
I'm sorry, I was told just minutes ago to do that. Let me reserve 4 minutes.
4?
Yes.
Okay. Thank you.
Thank you. 99% of this case flows from the trial judge's ruling on a stand your ground motion where she notes, this, and I'm quoting here from page 53 of the record, the state concedes that a forcible felony was occurring for purposes of stand your ground immunity based on the theory that once the invisible/imaginary plane where a window would be on a car was breached and someone inside the vehicle was touched, a burglary with battery occurred. Thus, the defendant is presumed to have held a reasonable fear that the occupants of the white BMW were in imminent peril of death or great bodily harm. My view and my argument throughout this case has been, once we all were in agreement, state, defense, and trial judge on that point, this is over. And I'll tell you why in a second, but the trial judge believed and continues to believe that, however, the presumption of a reasonable fear that the occupants of the white BMW were in imminent peril of death or great bodily harm is not enough. The law requires that the court apply an objective standard and find that a reasonably cautious and prudent person would find deadly force necessary, etc. And she goes on to find that this, in her view, it was not necessary to use deadly force on these facts.
Now, do you think it's correct that you're coming at this case through the lens of different statutes, that that the trial judge was coming at the case through 776.012, which seems to turn on this reasonable belief and is essentially a jury question, whereas you're coming at it through .0132, which addresses a situation where somebody's attacked in their dwelling or conveyance?
Right. Here's what I think she's doing. And I lack the ability to read her mind, but I think her analysis is appropriate for 012 cases. And if this was an 012 case, I'm not here arguing this. I'm probably trying to pick some other problem with the case to argue on appeal. But I've always made it clear in my pretrial motion and every point in this case that I'm arguing 013. Either she's mistakenly reading it as an 012 case and the argument and the presumption as an 012. But you see, I have a problem with that because the presumption statute is in 013. So she acknowledges the existence of 013, but then applies the 012 analysis to it, which I think at every point the disagreement that she and I have is based on that separation.
And you don't think that the protections of 013, it's entitled home protection and talks about, in one, a person who is in a dwelling or residence, that controls the application of this statute to this case, to the extent that this defendant was not in a dwelling or residence? How does 013 apply?
Because subsection 2 of 013, subsection 2, sub A, I realize you're reading the title and assigning some significance to it, and section 1 does deal specifically with home. Subsection 2 is broader than that, though, because you get down to the presumption is in the first sentence. A person is presumed to have held a reasonable fear of imminent death, et cetera, et cetera. A, if the person against whom defensive force was used or threatened was in the process of unlawfully or forcibly entering a dwelling, residence, or occupied vehicle. So it applies to occupied vehicles. That presumption, I think the presumption is I guess if you wanted to, is discreet.
It isn't bound by the context of I'm in my home and someone's coming in. I'm in my car, someone's coming in. That seems to be what 013, at least one, is addressing or setting the context for this statute, as opposed to I see someone going through the window across the street, I can shoot.
I think, well, first of all, if you were correct, then there is no reason for them to add the language of occupied vehicle in the presumption part of the statute. I've always been troubled with sorting through how these two statutes work with each other. And it's not it took me a while to sort it through, and I'm not sure I'll ever completely sort it through, but I've got a pretty good idea that subsection 1 and subsection 2 are discrete areas of focus by the legislature. And in fact, this court in
So
Bartlett,
that subsection 2 of 013 is effectively also a subsection 3 of .012 or something like that. I mean, it's part of 012.
if it was a better drafted statute, I think that would be the place to put it, so that everybody understands the flow of this. It's a very narrow set of cases, and I think part of what troubles everybody about it, and I told the judge myself that, do I think this is good policy? No. But the statute says what it says. It's not for us to rewrite it. It's not for you folks to rewrite it. It's not for the trial judge to rewrite it. It says that a person who breaches that imaginary plane, once you start applying burglary of an occupied conveyance, that they are presumed to have had a reasonable fear and are therefore permitted to act accordingly and to use deadly force. But I think it would be better if it had been placed in a different spot. Before you analyze before you analyze the question of whether it's good policy to start with. Sorry,
No.
you raised your hand.
So you don't think there's another part to the analysis? It's not just, did he have a reasonable, let's assume your client had a reasonable fear. You think at that point the statute allows him to just shoot indiscriminately out and not addressing whoever the actual threat is, just fire and hope that the crowd disperses? Is that what you think the statute allows?
I think
Because the
you asked
statute's
an
worded
interesting-
more specifically with respect to the actual person, it seems, the person actually causing the threat. And I think your client made in a statement, he didn't even know that the victim was there, he didn't see him.
I'm going to make the same point I made in my brief, Your Honor. If I stand in front of a small person, I'm going to obscure the view. If you have a mob of people, let's imagine this is the door, and I have a person in the back seat, because you can watch a video and you see this person in the back seat, and you have Mr. McQuay, the deceased, and several other people, in fact, but one guy, Mr. Denson, who's in a white, everybody calls them wife beaters, sorry, I'm sure it's a better name for him. But he is obscuring the view of Mr. McQuay, and Mr. McQuay is clearly a participant. You can see him in both sides of the video. He is one of the people, in fact, it's unclear who smashed the window in, but Mr. McQuay is one of the people who could have smashed the window in.
Could have,
But he is part of
but
a
not
group of
apparently
people.
actually doing it, because your client didn't see him at any point. So who is he firing at? And how is that
He just
reasonably?
happened to be firing at the guy who is participating in the attack on the car as per the videos. He fires in the direction of the people attacking the car.
Just generally the people attacking the car.
No, sir. I'm sorry, but we can have a debate about whether or not indiscriminately firing around is contemplated by the legislature's language. But if you have a mob of people, the fact that I can't see behind the front people in the mob doesn't mean I can't shoot at the people that are doing the illegal thing, i.e. the burglary of an occupied conveyance, which is a first-degree felony punishable by life.
Well, isn't that why the legislature put in reasonably in subsection 2 of 012? Or you just want to run away from 012 completely?
Do I want to run away from 012?
I'm just trying to understand what your argument is, because, I mean, 012 clearly contemplates there's a reasonable standard as to your client's action.
You
And
stated earlier, if this was an 012 case, then the state would win. So I think you are saying we're in somewhere else.
If it wasn't this particular kind of act, the legislature has sketched out a narrow group of crimes, generally speaking, burglary with an assault or battery of an occupied dwelling, structure, or conveyance. They say, we've decided that this is reasonable and it is conclusory, with 4 exceptions.
with respect to whether it's reasonable fear, right?
Whether it's reasonable to what?
Whether it was reasonable to have fear. I mean, it's presumed that he had fear. But 013 still assumes that the act, the shooting or whatever, or the force was permitted, and then it cross-references 012 and the others. So how do you...
Where does it cross-reference under 776.013 sub 2?
I'm sorry, under the immunity provision? Or we're not going to talk about immunity at all?
The whole thing is about immunity, Your Honor.
Of course. And for you,
How
to have,
does-
for you to have immunity under subsection, I'm sorry, I said 013 and I meant 032 sub 1. It says a person who uses or threatens the use of force as permitted, 012, 013, or 031.
As
So your
permitted.
argument is just it's permitted under 013, and that's the end of it. Is that's your argument?
Yeah, because that's what the legislature said, Your Honor. They said it clearly. Why would they write that statute that creates a presumption of reasonableness if they meant it to signify nothing? They did it for a reason under, if you read Scalia and, can't think of the other guy's name, the book on statutory interpretations and reading legal text, if the legislature puts language in there, they're assumed to have meant something by it.
Right,
The
but where do
judge's
you-
reading
where do you get
and
the
your
pro-
reading sounds like it means nothing. If the 4 exceptions don't count, there's actually a 5th implied exception that says I, the judge, just don't, for some amorphous reason, don't like the result that the presumption that the legislator created generates. That's inconceivable to me that they did that. Why would they write a statute that means nothing? They carved out an exception for a narrow set of cases. Happy to have the debate, although it's more of a political debate, about whether or not we should be allowing the Mr. Whitfields of the world to use that kind of deadly force. But the legislature says he gets to.
But it does so in 013. And 013.1 talks in terms of a reasonable belief. There is a reasonable belief standard in B of 013. And so then you get to 2, and it flushes out and very tangible. And I agree under 013 that when you get to 2, it spells out in some discrete terms that you don't find in 012 what reasonable belief looks like.
Yeah. That's why I totally agree with how we could have better structured this. But it says what it says. Here, you're reading.
But I guess the problem I still have is that 013 seems to contemplate I'm in the car, or the one defending and shooting against somebody coming in is in the car or in the house, in the dwelling.
No, you have the right to defend others. That's the.
Can I,
Sure. Go ahead.
Where I'm still struggling with, and the reason I was asking the question before, and I'm still not understanding how you can get away from 012, is can you point to me in 013 the language that provides a justification for your client in this context? Because it can't be sub 1, because that has to do with...
I totally agree. We're not talking about the subsection 1. Totally
Okay,
agree
so
with you.
where in 013, which provision in 013 gives your client some sort of justification to use force?
Okay, and we'll walk you through it. Subsection 2, a person is presumed to have held a reasonable fear of imminent peril or of death or great bodily harm to himself or herself or another. So that gets us to
That just gives them the fear,
Hang
right?
on.
Defines the fear.
When using or threatening to use deadly force that is intended to likely cause the death or bodily harm of another if, 1, the person against whom the defensive force was used or threatened was in the process of unlawfully and forcibly entering or had unlawfully and forcibly entered a dwelling, residence, or occupied vehicle. Mr. McQuay was actively involved in that act. Or that the person had removed or was attempting to remove another from the person's dwelling, residence, or occupied vehicle. Second, the person who uses this defensive force knew or had reason to believe that an unlawful or forcible entry at 2 minutes and 40 seconds into Mr. Whitfield's interview with police, voluntary interview, he says he saw them attacking his friends in the white BMW. And darned if he didn't shoot 2 people that were right there
Sure.
in within his sight,
So
Mr.
what's sub
McQuay
2?
and Mr. Denson.
What sub 2 gives you is a presumption that your client was in reasonable fear. Which provision of the statute then justifies his use of force in that situation?
As I've been discussing with Judge Osterhaus, 776.012, you read that language from sub 2 of 776.013 into 776.012. 2, a person is justified threatening or use deadly force, or if he reasonably believes that using or threatening deadly force is necessary to prevent imminent death, reasonably believes
Right.
is necessary, is then defined for this narrow set of cases, narrow set of situations, under subsection 2 of 776.013. And perhaps that's why this court in Bartlett said the creation of 776.013 eliminated the burden of proving that the defender had a reasonable belief that deadly force was necessary by providing a conclusive presumption of such. That's this court, 13, 15 years ago.
I'm sorry, can you still tell me which language in sub 2 of 013 gets you the rest of the way where you want to be? Where it says, where it defines reasonably believes that using it is necessary, such that we can't just use 013 for the first part of the presumption for the first part of the statute, and then look at the second part of 012 to consider whether the force was reasonably necessary, or however the language is worded.
The question in 776.013, sub 2, is what is a carve-out of a specific finding of reasonableness in the actions taken by a person if they are defending themselves or others when they are being attacked from outside a vehicle, inside a vehicle.
So, counsel, is it your position that the appellant is entitled to the presumption of reasonableness, even though he did not see Mr. McQuay before he shot him?
Yes, because Mr. McQuay was being obscured by another attacker. I don't see how that takes you out of this statute. You're by sheer line of sight. You are, if Mr. McQuay was an innocent and he was 50 yards back and got hit, that'd be an interesting question for us to have. Mr. McQuay was quite involved in this attack on those folks. The state agreed to it. The trial judge agreed to it. The evidence in trial agreed with it. The videos agree with it. He
But the
was
jury
up to his neck in this first-degree felony, punishable by life, and so the idea that line of sight somehow, whether it's you line up this way or if he's 3 paces to the right, that solves that magically creates the difference in how the statute's interpreted. That's I would hope that a court would not say something that outlandish. And I have 32 seconds left.
Yeah, I'll add a minute to your rebuttal. I'll add a minute to both sides. So.
Thank you.
Morning. Good morning, and may it please the court. My name is Ben Hoffman. I represent the state. I want to start with, I'm going to respectfully disagree with my colleague when he says 99% of this case boils down to the presumption. In 776.013, the state's position is 0% of this case revolves around that presumption because this is a 776.012 case. Mr. Whitfield gave a statement in this case, and he said why he fired the gun on the night in question. And in his pre-arrest interview, he said someone he identified at the time as Psycho fired at him, so he fired back. And throughout this interview, he was asked about the crowd, and he was asked about whether he was indiscriminately shooting. And his answer was consistently, I was shooting at one person and one person only, and it was because he shot at me first. That is a classic 776.012 case. Quite frankly, I don't know where 776.013 came into this case. There was no evidence whatsoever that Mr. Whitfield fired in order to protect the
Well, I
occupants
think
of
that's
vehicle.
a little, I won't say disingenuous, but you read that interview, and there's a lot going on at the scene, and that interview seems to reflect that he had friends or family in the car up there, and folks were going into the car, and there was a scene there, and that was partly what prompted his action.
So the evidence was he's certainly aware that there is a fight going on at the car. Respectfully, I wouldn't use the word mob the way my colleague does, because this is a 4th of July party, 2 in the morning. It's a drunken brawl, and I'm hesitant to even use the word brawl, because if you watch the videos, it's more slapping than anything. But setting that aside, there's no question Mr. Whitfield is certainly aware that there's a fight going on at the car. But he specifically says why he fired the gun, and it's not just confusion about maybe he heard a gunshot, maybe he didn't. So he first says a shot rang out, and that's a direct quote. And then if you go about 10 seconds past when he says that, and I want to make sure I actually get citations for this. So first he says, I'm quoting, a shot rang out. And this is at around 2 minutes and 42 seconds into the interview. If you go forward about 8 to 10 seconds beyond that, he then says, I shot back. I shot back implies I'm being shot at, or at least gunfire is coming in my direction. And at this point, he's certainly not among the crowd that's at the car. He's not a participant in the fight. He's away from that. He's saying, I got shot at, I fired back, that's my reason for shooting. And
Is that key to your case? If we think that, if we don't think that it is so clear that he was returning fire, but that he was responding to this scene in the mob and people going into the car, does that mean, is that consequential for your case?
I'm not quite sure I understand.
If he did shoot because were people swinging into the car and attacking his, I think it was a friend or cousin, I forget which one, but they all came from Monticello. If that was the reason for his shooting, does the defendant win?
Okay, so I think so if I understand what you're asking, if his actual subjective reason for firing was to actually prevent.
Yes, that's right. Thank
Okay.
you.
If that's subjectively his reason, no, I still don't think it ends there. We are still, and even 776.013, we're still under a reasonable standard. So he has to actually believe, and it's actually in the jury instructions that were given in this case, in the standard instructions. It's not just that is his subjective reason for doing it. He has to actually believe that it's necessary in order to defend the people in that car. So he has to actually believe that they're in danger, and fine, there's a presumption. He believes that they're in danger, but the instructions, which are tailored from the statute, go on to say a reasonable person in those circumstances would conclude that the only way to avoid that danger is through that use of force. And I did print, bring that portion of the instructions. So this is page, of the trial transcript, which I realize this is all one record. It's page 556 of the trial transcript. This is the judge instructing the jury. So at the bottom of the page, it reads, Brad Whitfield was justified in using deadly force if he reasonably believed that such force was necessary to prevent imminent death or great bodily harm to himself or another, or to prevent the imminent commission of a burglary against himself or another. We then go down to the bottom of page now 557. This is part of the same instruction. It then reads, in deciding whether Brad Whitfield was justified in using deadly force, you must consider the circumstances by which he was surrounded at the time the force was used. The danger need not have been actual. However, to justify the use of deadly force, the appearance of danger must have been so real that a reasonably cautious and prudent person under the same circumstances would have believed that the danger could be avoided only through the use of that force. And then, I won't quote it, but then in the very next paragraph, it does impose a subjective standard that he has to actually believe that they're in danger. So again, our position, I just want to make it clear, our position actually is that he did not fire to protect the occupants of that car, understanding that you're asking about.
And that makes a difference as to whether this is a 012 case versus an 013 case. If he was firing because of the attackers on the car, then this is an 013 case? Is that?
I mean, yes. So if he says, just for sake of argument, let's just say in his interview he says, I saw this group of people attacking my friends in a car. I was concerned, so I fired to protect them. Certainly, that is some evidence to get you into the realm of 776.013. But our position is he said why he fired, and that's not why he fired.
Well, if we are in 013, how does subsection 2, what work does subsection 2 do to somebody in that circumstance where there is a forcible felony going on that he responds to by shooting into the attacking crowd?
So so subsection 2, I'm pausing just for a second because I'm looking at subsection 2B before I answer. Subsection 2 certainly gives him the presumption, and I don't.
Presumption of what?
So there's a presumption of fear.
Okay.
The problem with 776.013 is it's lumping together things that really don't belong together, quite frankly. So for instance, if I'm in a dwelling or if I'm in my own car, stopped at a stoplight, and someone's breaking into my home or someone's trying to, say, carjack me while I'm stopped in my car, obviously there's a presumption that I'm in fear that someone is breaking into my home or someone is breaking into my car to do harm to me. Where 776.013 gets confusing is it's lumping together into that presumption of fear things that don't belong. So this isn't a perfect case of it where just because you see what can be defined as a forcible felony, not all forcible felonies are actually dangerous to the point that you're going to be worried that someone is going to get hurt or killed in the process. And this case is a perfect example of it. We have what amounts to a fight, and the state even made a point of this, I think it's at the Stand Your Ground hearing, that if that car wasn't there, we'd be talking about a misdemeanor. So this is lumping together things that really should not be lumped together.
Okay, going back to your analogy, let's say I am the driver and somebody is coming in and somebody has swung and what have you, and me, the driver, defends myself by doing the shooting. Are you saying that subsection 2 gives me a presumption of fear but does no work as to immunizing me, that it still goes to the jury on reasonableness.
Yes, so at the end of the day, it is a reasonableness standard. And reasonableness in every context has always been a totality of the circumstances analysis, whether we're talking about search and seizure, whether we're talking about self-defense, defense of others. Reasonableness always means totality of the circumstances. And in this case, we have a crowd by a car, and by the way, not everyone in that crowd is even involved in the fight. There's at least one person, if not two, in that video that's trying to break it up.
Right,
There's people walking by.
I mean, you keep going back to the facts on the question of reasonableness, but you're sitting here, you started your argument by almost conceding, well, if this were in this category, it'd be a 013 case, but this is a 012 case, as if like that has some magic language. The question I think that the chief asked, that I think I asked as well to other counsel, is it's a bit more basic. Where in 013 gives a justification or immunity, however you want to call it, for the act that was taken by the defendant in this case? I mean, where is that language?
And
That says that this is justified in this circumstance.
And I guess to answer your question directly, it's not in there.
I know it's not in there.
Right, and maybe this is part of this is a badly, poorly constructed statute.
Well, before
But
everyone
it's-
dumps on the legislature, I mean, okay, I mean, it's poorly worded only in the sense that it's not getting you or the defendant the thing that they want in one place. But as a policy, the legislature has stated, regardless of whether the Division of Law Revision put the subsection in a different place or in a different section, as a policy, there is a statement there. It says that here's a presumption of fear. You can apply that any way you want, I guess, in context. But the work that I think the chief's talking about is which statute's doing the work of justifying the act.
And it's still 776.012.
Of course it is.
Right, so,
So, and I'm assuming it's the state's position, regardless of whether he was shooting because it was a burglary of a conveyance, or whether it was just shooting in defense because someone shot at him. It's still 012, isn't it?
at the end of the day, yes. So when I said, I guess to answer.
Because I don't think we're arguing over the presumption so much as is it a jury question on the reasonableness side of it? Was
Yes,
it reasonable to shoot in that instance?
Yes, and to clarify, I guess when I was answering the Chief Judge's question and saying, for the sake of argument, that subjectively he shot to protect others, to the extent that it could be construed that I was saying we're only in 776.013, that's not where I was going. I was just saying you can get that presumption. But yes, ultimately it's the state's position. 776.012 controls, I guess, regardless of what is subjective, whether it's self-defense or defense of others, we are in 776.012. And on the question of whether it's a jury question, I do want to refer, because I know Judge Tannenbaum, you were going back to 776.013. And this question of whether the presumption is rebuttable, I want to focus in on subsection 4 of that statute, where it basically just provides the pretrial procedure of saying once, I'm quoting now, once a prima facie claim of self-defense immunity from criminal prosecution has been raised by the defendant at a pretrial immunity hearing, the burden of proof by clear and convincing evidence is on the party seeking to overcome that immunity from criminal prosecution, provided in subsection 1, which includes both .012 and .013. The use of the term prima facie is interesting, because in Black's Law Dictionary, prima facie inherently means it is rebuttable. In fact, I think the actual definition, I wrote it down. The actual definition in Black's Law Dictionary for the term prima facie case is the establishment of a legally required rebuttable presumption. So regardless of whether this presumption applies or doesn't apply, if we're talking about now JOA for one of the issues and whether this should have gone to the jury, it's the state's position certainly that even if Mr. Whitfield subjectively fired because he was defending others, which we're not conceding, but even if he did, then the state certainly did present evidence to at least call that into question and make it a jury question. One, as to whether he actually fired for that reason, and that is a jury question. And two, even if the jury were to conclude that he didn't mean what he said, when he said that I fired because someone fired at me, even if they disregard that and say he actually fired because he's worried about his friends, it's still a question of whether he was reasonable, given the fact that not everyone in that crowd was actually involved in that fight, given the fact that there's people clearly walking by that have no idea what's about to happen. And
So,
as the
counsel,
judge
is your position that conclusive presumptions are in fact rebuttable?
it's our position that it's not a conclusive presumption. I'm hesitant to use the word conclusive with irrebuttable. So I understand this court's decision in Bartlett using the word conclusive. I'll point out Bartlett, that's not the holding of Bartlett. That's just a statement in passing. Bartlett was, I think, the case about whether the investigating detective should have been allowed to actually say that he ruled out self-defense before seeking an arrest. But it is our position that this is not, whether you want to use the term conclusive and irrebuttable, I hesitate to use them interchangeably, but assuming you do, it's our position that this is a rebuttable presumption and that the state, at a bare minimum, should be allowed to put on evidence to rebut the factual premise of his claim that he was firing in defense of others. We did put on evidence to rebut that in the form of Mr. Whitfield's statement, and at bare minimum, since we're now talking about the judgment of acquittal standard, that is more than enough to make it a jury question.
Regarding section 776.031, is it your position that the appellant must have been in the white BMW at the time of the shooting for section 776.031 to apply to this case?
Could you reword that? I'm sorry.
Okay. Is it your position that the appellant must have been in the white BMW at the time of the shooting for section 776.013 to apply to the facts of this case?
Okay. Versus being outside of it. I
Versus
see what
being
you're
outside.
saying.
That is correct.
Yes, I think that is a fair reading of the statute in its context. I do agree with that. Understanding that below, the state was addressing kind of two competing theories, because below, he still pursued self-defense. But understanding that the state's main contention below, this wasn't reasonable, I think you could, given the way, again, this statute is putting things together, for instance, dwelling, I agree. So for instance, if I were, I don't know, we just had Halloween. Let's say I was walking down the street on Halloween. There's lots of people walking around, and I see somebody breaking into, or at least that I think is breaking into a random house, and I decide to start shooting when there's kids walking by, and I hit a kid, God forbid. Yes, I think it is a fair reading that I'm not going to get the presumption of fear when I am shooting into someone else's house. Again, that's an analogy, but yes. Direct answer to your question is yes.
Is it relevant that to this consideration at all, that the jury actually came back with a lesser included manslaughter? It's almost as if they understood exactly what happened here, and they said, well, he basically shot, like unreasonably shot into a crowd as opposed to a person, and unfortunately killed someone. And it was almost like culpable negligence in a way.
Right. And
Seriously culpable negligence.
And it's certainly possible. So again,
In other words, like in light of all this and how the jury came back with their verdict, how could we legally, justifiably take that away from the jury and second guess the verdict, or whether the evidence was sufficient to go to the jury in the first place? I mean, it seems like a reasonable verdict. I mean, maybe not. I mean, I'm not judging the weight of the evidence, but a reasonable person could look at this verdict and conclude that that was supported by the evidence.
certainly. And certainly, there's no reason to believe the jury was confused by these instructions at all. I think the jury may have actually been confused if the judge had added what my colleague was asking her to add about those exceptions that don't apply. But yes, so interestingly, during closing argument and throughout the trial, the defense did present this multiple shooters theory. It is certainly possible that the jury accepted it. I don't know. Obviously, I wasn't in the deliberation room, but it is certainly possible. And I think I did argue this in, I want to say it was the 5th issue, the one about the inconsistent verdicts. It is certainly possible that the jury made a conclusion that we think he was fired at first and that he was justified in defending himself, but that the manner in which he did it was unreasonable, in that he's shooting into a crowd, he hits someone that by his own admission he didn't see. There's people there that aren't involved in it. There's people walking by. It is certainly possible, to answer your question, that yes, the jury bought that alternative theory, and that it is reasonable based on the evidence, and that they weren't confused by any of this.
So is the appellant then inadvertently misconstruing what the state stipulated to and what it didn't stipulate to? It doesn't sound like the state stipulated at any point or conceded anything at any point about whether it was reasonable to shoot in those circumstances.
Right, and I don't want to say he's intentionally misconstruing it, but yes, there is certainly the state, again, keeping this in context, that at the stand your ground hearing, the state is responding to two separate defenses. He's responding to a defense of others, and he's responding to a self-defense claim. The only concession the state actually made, and I just reread this portion of the record yesterday, the only concession the state made was that the act of fighting by the car and punches or slaps, whatever you want to call them, going through the plane amounts to a burglary with a battery. That's the only concession the state made. I'm not even sure I would agree that the state actually accepted the burden. Not here to relitigate that, but it doesn't matter. The state put on evidence to rebut the factual premise of the claim, which is all it was really required to do, and that was more than enough to get past the stand your ground hearing. The judge obviously made factual findings adverse to Mr. Whitfield, and that was more than enough to make it a jury question. And I see my time's expired. Understanding we didn't address all the issues, I ask that the court affirm on all issues. Thank you.
Thank you, counsel.
Let me make one comment first. If we're discussing the jury instructions, then I would ask that you remand this case for a retrial where the jury is instructed on the only 4 exceptions that exist to 776.013. I requested that. The trial court denied it. That contributed to this verdict because it makes it impossible for me to argue to the jury the very issue that I'm arguing here.
But your argument here, whether those that is added to the jury instructions, I still don't understand how it gets you out from the other part, which is that you have to that the jury gets to decide whether it was reasonable. You seem
I got 39 seconds. I got the issue.
Okay.
We are dealing with, under this law, I think hopefully we all agree that we're dealing with an objectively reasonable person standard. That's what all the cases say. A person is presumed, this is under 776.0132, a person is presumed to have held a reasonable fear. This is a comment on what inhabits the mindset of the person who shoots. He held a reasonable fear of imminent peril, death, or great bodily harm to himself, herself, or another. So, answering your question, another person, a different person who's not in the car. When using, and therefore I have used or threatened to use defensive force that is likely or intended to cause death or great bodily harm. That answers your question. That is describing the mindset. I am presumed to have reasonably feared for their safety and acted accordingly. That's what 776.0132 says. You have to read it in paramateria with the first sentence of 776.012, and that's why this court said in Bartlett what it did. It is a conclusory presumption. It is game, set, and match, and to the extent that there's a suggestion that I have made some false statement to this court about what the state agreed to and stipulated to, I can categorically tell you that I did not.
Thank you, counsel.
Thank you.
All right, we'll move on to the next case. Give counsel some time to gather their things. All right, our second case of the morning is case number 22-3433, McDonald versus Florida Birth-Related Neurological Injury Compensation Association et al.
Good morning. May it please the court, Carol Link on behalf of Erica McDonald, the appellant. I'd like to reserve 2 minutes for rebuttal.
Okay, thank you.
Words matter. This maxim is particularly true when those words have been determined by the Florida Supreme Court to be clear and unambiguous. I'm speaking specifically with regard to the statute at issue in this case and the Florida Supreme Court case that came out in 2010. Facts are very straightforward. My client gave birth in 2015 at Tampa General Hospital. The delivering physician was an employee of USF. Unfortunately, tragic circumstances existed, and an acute hypoxic injury occurred, oxygen deprivation. The child is now 8 years old, cerebral palsy, can't speak, eat, walk on his own. There were 2 sets of notices given to my client under the NICA statute. One set was given on May 4th, 2015.
Can I ask you a preliminary question?
Yes, Your Honor.
Sorry to break you off on that. Do you acknowledge that 766-313 bars your client's claim to the fund?
Under timeliness?
Yeah.
Yes. That's correct. So
the ALJ's final order determining that, in fact, your claim is barred is not an erroneous determination, right? You can see that was correct.
The timeliness is not an issue.
Okay,
That's
so
correct.
if your claim is barred, why are we here? Like, what else are you asking this court to do?
I'm asking this court to allow us to pursue our common law civil remedies because the statute.
How do we get to do that? And how would the ALJ have any say one way or the other whether you can pursue a claim in circuit court?
Perhaps you're raising a constitutionality question.
I am raising a constitutionality
Okay, well then
question.
I do appreciate that very much.
I mean, not directly, but my question is, okay, the ALJ has said you cannot file a claim against the fund because
Right.
you're barred.
Right.
That seems to be correct. I mean, you can't fuss with dates.
Didn't raise it.
Right.
Well,
And so at that point, so the ALJ, whose authority goes only so far as the executive branch,
right.
make findings if it's relevant to a determination within the executive branch, and whatever else this ALJ has said, the order is you don't get a claim against the fund because you're barred. That's the end of it, and that stays in the executive branch. So why does it matter what the ALJ says about facts? He's not an Article 5 judge. He's not a judge at all. He's
Right.
an administrative hearing officer.
Judge
What's the
Tannenbaum,
question here?
You raise a very interesting issue that hasn't been briefed, that the parties haven't raised. The issue of timeliness and being barred is something that was factually determined by the ALJ. But the ALJ also found that the claim was compensable under the fund. So we went off on this tangent that we're here before this court. And it's not an unreasonable tangent because the defendants are still pursuing NICA immunity. They're still pursuing it. They're saying where?
Yeah.
Well, I presume they will when we go into circuit civil court. They'll raise this. So that's why
Isn't all
we're.
of this shouldn't all this be litigated in
Circuit civil?
in an Article 5 court?
A court.
And then, whatever happens in the circuit court, then there's an appeal.
Right.
On whether notice, immunity, all of that kind of stuff.
That might be the case, Your Honor. And if that's the case, then we would need the opinion of this court to say that, though, because at this juncture, we're here now, and they are going to, when you ask the question of them, they'll say, we get NICA protection. So, and I guess your point is that we're premature, that we're making these arguments now.
Well, you're suggesting that there's error in some way in an ALJ order that you concede, because you have to, legally.
Timeliness, barred by timeliness, right.
Is correct as a bar. That you don't, basically it's denial of your claim.
Right.
However you got there,
Right.
it's a denial of your claim.
Well,
And so you're asking us to vacate that part of the order that makes findings that don't seem necessarily relevant, but even if they were, has like zero legal effect outside the executive branch.
these are great questions. I wish we had briefed them, because you make an excellent point. I think we're here, and I think we need the court's ruling now on the NICA, whether it's been checked the box and they followed the statute that contains clear and unambiguous language, or they didn't, because we're going to hear about it when we do pursue our civil remedies in tort and under common law. And if I could just to pivot back, Dr. Brown is not in any four of the forms. They're in the supplemental record at 1299. I cite the record because it's important. The forms are interesting. They're on Tampa General Hospital letterhead, not USF. And no one can tell this court, no lawyer who will speak to you this morning will tell you that Dr. Brown's name appears on the forms. The Florida Supreme Court in 2010, after the 2006 50 C.A. Jackson case, said that each hospital and each participating physician must comply with the notice statute. So Dr. Brown unequivocally has not complied with the statute and doesn't get the NICA exclusivity protections. And what's at issue is my client's constitutional right. It's really interesting history behind the NICA statute comes from this court, the Galen decision that went up to the Florida Supreme Court. Florida Supreme Court and Galen explains that Florida wanted to follow Virginia, wanted to follow what Virginia was doing in terms of medical malpractice protections. And what the Florida Supreme Court said was, when they looked at the task force on this particular statute dating back to 1987, the task force said we have to have this notice requirement to avoid a constitutional challenge. That's what Galen said when they read the legislature's task force committee notes and legislative intent. So we're talking about a very important part of this statutory scheme. My client loses her constitutional right if they follow the law. Dr. Brown did not follow the law. USF did not follow the law on behalf of Dr. Brown. USF did not give notice, because it's very interesting.
Counsel, is it your position that the only notice below that would have been sufficient is if Dr. Brown had handed her the NICA brochure when she walked into the hospital room? That's your position?
Dr. Brown or even USF, but nobody from USF nor did Dr. Brown give her notice. My client got zero notice that Dr. Brown is going to be a NICA participating physician and that she would be delivering her baby. What's interesting, Your Honor, is that on the two notices that USF claims are their notices on Tampa General Station letterhead given by a Tampa General Hospital employee, they have 19 doctors listed. Why list the doctors if you think that the word and the catch-all, all, including but not limited to, would check the box and comply with the notice statute? But in the first notice with USF's name embedded in the document, they give 19 names. On the second notice given on 9/21/2015, they have 25 doctors. I think when you look at the typographical box, it looks like maybe there was some type of computer error, and so some names were left out. It's hard to tell. Who knows? But here's the point. They started to comply. They knew in 2010, the Florida Supreme Court said each participating physician. So they tried, or they started to, they just didn't meet their statutory obligation that would allow my client to waive her constitutional right to a trial by jury. They didn't list Dr. Brown. Notice is not statutorily compliant for Dr. Brown or USF. And
So the way this will work, fusing both of my colleagues' questions, is that you will go to circuit court, they will defend NICA, you will
Right.
say, well, no, because you didn't comply with notice requirements.
correct.
See this issue preclusion out here by the first DCA?
Worried. I can't waive it today, that's for sure, because I don't want to be told by circuit court and then wherever jurisdiction that we're in, that this should have been determined here. So I'm here making my client's argument today. I don't want to lose the right to make this argument because I know we win. We win because the law wasn't followed. And the Florida Supreme Court said that this statute is clear and unambiguous. And they must give notice if they're going to get that quid pro quo. If they're going to get the protection of NICA, they have to give notice to my client.
But counsel, how do we address your procedural arguments if we affirm the ALJ on the timeliness issue? How do we get there?
The issue of timeliness, though, Your Honor, isn't teed up before this court. I mean, it is in the order.
It could be tipsy coachman, couldn't it? I mean, everybody agrees that there's a timeliness issue here.
It's
so
not
a
raised, yes.
Tipsy coachman affirm.
I would hope that this court would not affirm in that manner, because that would
But if
give
we did, how do we address your procedural arguments?
my argument. Well, I would ask the court to address my argument by saying clearly that the Florida birth-related case from the Supreme Court in 2010 required each participating physician to give notice, and that they did not do so as to Dr. Brown.
Well, in an opinion, how do we explain affirming the singular disposition of the AOJ here, which is that your claim is time barred? Affirming, but then explaining that what the AOJ did regarding
The notice issue.
and
Yeah.
everything else doesn't apply in a trial case, or that they do or do not get immunity. I just don't understand. Let's take two scenarios. So one, let's say we affirm.
Yes.
I don't know what we would say then that helps you, or what happens if, answer me two questions. So if we affirm, what happens next for you and your client? And if we vacate
Right.
the ALJ's order for whatever reason, what happens next on that?
If you affirm, we would file our circuit civil remedy and pursue that. And I anticipate that the defendants will say, no, you're precluded, do a motion to dismiss or summary judgment, and raise the statute and say that they complied by the law. The first DCA affirmed. They must have found, despite your best efforts at the 20-minute oral argument, that our briefs pointed that we complied with 766.316, and Dr. Brown was a participating physician, and USF gave this catch-all notice that satisfied the constitutionality challenge.
And your argument response would be
A PCA has no precedential value,
Sure.
and
that a statute, the legislature doesn't have the authority to designate an executive branch administrative hearing officer to make adjudications of fact that have legal consequences between two parties outside the executhat branch, right? That's what you would argue.
Absolutely correct. I think you have another case pending right now where you have ordered jurisdictional briefings on that precise point in jurisdiction.
I'm on that panel, yes.
I'm sorry.
I am on that panel.
You're on that panel. Okay, I'm not counsel in that case. I'm aware of it, so it's an interesting issue. And then to answer your other question, if you reversed, then that finding would allow me to pursue my circuit civil remedies. And that's
Right, but how do we vacate? I guess that's the opposite. So on vacating, what would the vacating look like? What is the legal
Vacate.
error that the ALJ committed by disposing of a case because it's time barred, but then throwing in a bunch of other stuff, findings He calls findings and conclusions of law, none of which necessarily are relevant to the disposition. How do we, what's the legal basis for vacating that order?
Well, they're relevant to the disposition in that they preclude me, as we stand here, I'm concerned that they preclude me from pursuing my circuit civil remedies, because that is
Because of what the third DCA said.
Right,
Without
yes.
any analysis whatsoever.
Correct. I think Perez or, what is it?
EMO.
University of Miami. So as a matter of law, I need this court to say the claim is not compensable. The ALJ found it was compensable, and then found that they have the NICA exclusivity protection. So I'm barred from, as I stand now, with that piece of paper in that order. They will use it against me in circuit civil. So that's why we're here. I understand the court's concern about the timeliness. We didn't raise that. I didn't get a chance. I know my time I'm still good, but I need to address Tampa General Hospital because I think it's abundantly clear based on the Florida Supreme Court in 2010 that each means each, and Dr. Brown did not give notice. So we should win, and we should be receiving vacatur of the order with regards to that notice issue. The second point with Tampa General, because Tampa General is the one who's on the letterhead. Tampa General is the one with the employees who go and meet with my client and give the forms twice. Tampa General, however, this is interesting because when you look at the statute, 766316, you have to read it in totality. You can't carve it up. You can't go straight to the last sentence. Tampa General wants this court to go and read the last sentence in a vacuum and say, we have a rebuttable presumption because your client signed the form.
Well, counsel, do you agree that appellant had the burden to prove that the notice she got was insufficient?
Yes, Your Honor, and we did. We did. But here's my point about the statute. Yes, we absolutely did. The statute, when you read it in totality, says that the notice that's required shall be provided on forms furnished by the association that shall include a clear and concise explanation of the patient's rights. How did we prove that there's no evidence that we received a form, clear and concise rights? Yes, we signed a notice, but the notice is not the form. The notice is that signature page saying we got the form. The form is the brochure, and the brochure is not in this record. The brochure was not scanned into my client's medical records, and it defies logic that in today's day, when I think all judges on this panel are using computers and iPads as our counsel, that it defies logic that a medical provider can't scan in the requisite form, and I'm talking about the brochure. The notice is not the form. We've merged those, and practice has merged them, the medical providers. They have that notice, so they have a sheet of paper that my client signs, but the sufficient notice that's on a form approved by the association is the brochure. We have no evidence that my client was given a clear and concise explanation of her rights under NICA because the brochure wasn't in her medical records. And so there's no excuse that USF could not amend its list of 19 or 25 doctors to add Dr. Brown, as they clearly could have done when they changed it. There's no excuse for Tampa General to be unable to scan the brochure, which is the only evidence of meeting their statutory duty of giving my client clear and concise rights. So Tampa General wants to run straight to the signature and say, your client signed the notice, therefore we get a rebuttable presumption. But you can't do that because the notice is just the sheet of paper. You have to show that my client got notice of her clear and concise explanation of her.
So your argument is about the substance of the form or whether she got the form?
It is about the substance because it's not in the record. And I think we.
So it's sort of like suing on a contract, but it's not your obligation in challenging the contract to put forth the contract that you're suing on.
Yeah, but they're the ones, I am suing, but they're the ones who want the privilege of being protected and shielded under NICA. So it's their duty under this statute to provide, and it's a mandatory duty, it's a shall, to provide not just the notice that we sign is irrelevant. That's, well, it's not totally irrelevant because it lists some doctors, but not Dr. Brown. But it's the brochure that is the substantive form that they have not been able to say that they provided to us. That applies to both USF and mostly Tampa General, because they're the ones.
You're into your rebuttal time. Just
I
wanted
see
you to
that,
be
Your
aware.
Honor. I also want to mention that this court in the Board of Regents versus Athey, even before the Florida Supreme Court said it, in 1997, this court said that notice on behalf of the hospital, it by and in of itself does not satisfy the requirement imposed on the participating physician to give notice involved in the delivery. Although I cited the Athey case in my initial brief, it wasn't addressed by appellees, and it helps reverse and remand, we ask from this court. Thank you.
Thank you.
May it please the Court, Annetta McCleary on behalf of Tampa General Hospital, and we will be dividing up our time. I'll take 9 minutes, counsel for USF. Board of Trustees will take 9 minutes, and NICA will take 2 minutes.
Okay, I'll leave it to you all to sort that part out. Thank you.
And I'd like to just start with what's not in dispute in this case, and that is that Ms. McDonald received 4 separate notice forms, signed 4 separate notice forms on 2 separate occasions that she presented. And let me back up a little bit. I'll be addressing the rebuttable presumption issue specifically. Ms. McDonald signed 4 separate notice forms.
What about the indisputability of the fact that the claim was barred, time barred, which opposing counsel has conceded as she has
Yes,
to?
it is time barred, which means that they do not have a remedy in NICA, but the notice issue specifically is determinative of whether they will be able to pursue their civil circuit claims, and it's determinative of whether we will be able to raise as an affirmative defense.
Sir, and you heard my questioning. So at some point, can you get and address that, how what you just said is actually true under the law?
I'm sorry.
How is what you just said true under the law? Could you walk me through that? Like the ALJ's findings
Sure.
in the order that led to actually just a disposition of the claim because it's time barred, how does that have any effect in a eventual suit in trial court?
The notice issue does, and the ALJ
Why?
has the exclusive jurisdiction. So Section 766309 specifically says that notice, if it's raised by the party, the ALJ has the exclusive jurisdiction to determine the notice issue.
Exclusive to an Article 5 court, is that what you're saying? You're saying that the legislature has the authority to take away judicial power from a trial court invested in the executive branch? Is that what you're saying?
So again, we haven't had the time to fully, to brief this issue before the court, but based on the plain language of the statute, the notice is decided in DOA by the ALJ, and then that will be determinative of whether our client can raise immunity as an
Sure.
affirmative.
In fact, no one, I mean, there's a lot of briefing in this case, no one addressed the question. So what is the perception of an ALJ? How does everyone view an administrative hearing officer and the effect of a finding outside the executive branch? Is it the perception that it doesn't matter who adjudicates facts, as long as that the facts are adjudicated, that those are binding forever on everyone, regardless of the forum?
I'm not sure I follow the question.
Well, so the statute says that the ALJ can make a determination about notice, and which may have an effect on on immunity. But that's all very interesting if it's happening in the executive branch, in a proceeding in the executive branch. What you were just asserted is that those findings will have effect outside the executive branch and essentially make a preclusive determination of fact that binds both parties, which essentially changes the legal relationship between the parties outside the executive branch. That sounds like the exercise of judicial power. That's what Article 5 judges do. So help me understand why any of this matters.
Sure, and again, it wasn't raised and we didn't have a chance to brief it. If I could go back
Yeah, go
to the, and we'd be happy if the court orders to provide further briefing on that issue, and perhaps Counsel for NICA might be able to further address that issue. I would like to just go back to the rebuttable presumption, because again, we had 4 separate notice forms that were presented to Ms. McDonald. She stipulated.
Counsel, before you go back to the notice form, this is just a follow-up, just Tannenbaum's question. Does the ALJ's determination on that notice issue has res judicata effect in any subsequent judicial proceeding?
The Tampa General Hospital will be able to raise as an affirmative defense NICA immunity based on the ALJ's determination of notice. Going back to.
And that's based on what?
I'm sorry?
That's based on what?
I believe this court in TAB addressed this, and again, Section 766309 provides that the ALJ has the jurisdiction to determine that. The case law specifically says that the healthcare provider will raise as an affirmative defense NICA immunity in the court. But just going back to the rebuttable presumption issue, we have 4 separate notice forms that were signed by Ms. McDonald. She stipulated that the signatures were hers, and so what that does under Section 766316 is it raises a rebuttable presumption that the notice requirement was satisfied. And so, based on the plain language of the statute, there was absolutely no requirement that Tampa General introduce the actual brochure into evidence. The
Well, why
presumption.
wasn't the brochure introduced into evidence?
I'm sorry?
Why wasn't the brochure introduced into evidence?
And that's not clear from the record, but it didn't have to be, because we're operating under the presumption. And this court in TAB specifically addressed this. This court said the NICA statute tells healthcare providers exactly what they need to do to avail themselves of a rebuttable presumption that the notice requirements have been satisfied. Signature of the patient acknowledging receipt of the notice form raises a rebuttable presumption that the notice requirements have been met. That necessarily means a presumption that the NICA brochure that was handed to Ms. McDonald included a clear and concise explanation of the patient's rights and limitations. And so, based on that presumption, the ALJ was required to assume that legally sufficient notice had been given, at least until the plaintiff introduced evidence that sufficient notice was not provided. And I'll just like to refer specifically to the testimony that petitioner contends was sufficient to rebut the presumption. Petitioner says, and I'm referring to page 16 of the reply brief, where petitioner says that the cross-examination of the hospital's witnesses demonstrated that Tampa General does not keep a copy of the brochure in the patient medical records and didn't have one at the final hearing, that they did not know what was in the brochure, and that the patient access specialists do not explain the brochure's contents to the patients. Not one of those is a requirement of Section 766316. There's no requirement that Tampa General Hospital, in the statutes, you will not find it, that Tampa General Hospital is required to upload a copy of the NICA brochure into the patient's medical records. There's no requirement that the hospital employees memorize the brochure, and there's no requirement that they explain the contents of the brochure to the patient. And really, if you look at the statute, it requires that notice be provided on a form furnished by NICA so that there is uniformity in the way that notice is provided, and so that there's not.
Counsel, regarding the notice, how was the USF notice sufficient when it was Tampa General, not USF, who provided it to the appellant?
And I believe that goes to the question of whether Dr. Brown gave sufficient notice, and I'll let counsel for the USF Board of Trustees address that question, if Your Honor will allow. So again,
What is the effect of the ALJ's determination? It's the second part of the one-sentence disposition, time barred, but there's otherwise compensability. What is the effect of that latter part of that statement? What does that mean to say it's compensable if he determined that it's not because the claim is time barred?
the claim is time barred in the sense that the petitioner does not get their remedy under NICA, but it's compensable,
Which means it's not compensable, right? That they're not entitled to compensation under the fund because the claim is time barred.
Compensable, except for that it is time barred. Compensable.
Well, it's not except for. It's not like if a suit is barred by a statute of limitations, well, you would have won, you're liable, except for the fact that it's barred by the statute of limitations.
Sure.
It's just, no, your claim is barred by the statute of limitations.
And I'm referring specifically to Section 766309, which lays out the four separate determinations that have to be made for compensability to be found, which is whether the injury is a birth-related neurological injury, whether the obstetrical services were delivered by the participating.
Sure. Right. But the claim's time barred.
It is.
So why does that provision even matter? I mean, there's nothing else for the ALJ to do. If the claim is time barred, it doesn't matter. It's not compensable because you can't get compensation under the fund because the claim is time barred.
Correct. And again, I would just point the court to the language in the statute that specifically, if raised by a party, gives the ALJ jurisdiction to determine the notice issue, which is a precondition for the healthcare provider to be able to assert immunity in the circuit court. And I think this, again, goes back to the constitutional question, which I'm afraid we haven't looked at as thoroughly as in order to be able to answer those questions.
I wonder how many more oral arguments we need to have in this case before people start briefing it, because this is at least the second, if not the third one that has been raised.
And I believe I will hand over the rest of my time.
Thank you.
Thank you.
May it please the Court, Jason Nazarone on behalf of USF Board of Trustees. Counsel started off her argument with words matter. I will submit to the Court that the lack of words also matter. To address Judge Lewis's question, Judge Brown and USF absolutely gave notice of their participation in the NICA program. Counsel wants this Court to provide an overly broad reading of the Florida Supreme Court's ruling with respect to the word each. There is nothing in Florida statutes or Florida case law which talks about how notice has to be given. In fact, if you look at, and this is cited in my brief through a webpage, NICA itself says the intake personnel should be instructed on how to provide notice to each individual person on behalf of the doctors, on behalf of the hospitals, on behalf of the providers. If you look at these forms, it couldn't be any more clear that USF and
But how do you respond to the appellant's argument that the appellant never met Dr. Brown before the day of the delivery and may not have known that she was a USF physician?
She doesn't need to. Dr. Brown doesn't need to, because the intake personnel gave her a form that said USF is participating, all physicians are participating, and that would include Dr. Brown. Now, I understand counsel's argument in going and attacking this notice, the form, but again, we look at Florida law, and there's really no case law that talks about what needs to be included in the form. The brochure needs to be clear and concise, but all it says is once you sign that form, once you sign that, you are conceding that notice was provided and it was adequate. There's no testimony that the appellant asked questions. There's no testimony that she didn't concede that she was provided adequate notice until suit was filed. So essentially what she's doing is she's going back and saying, well, wait a minute, I didn't get notice, I didn't know. Well, that's self-serving. That's the whole purpose of signing this form.
At what point of giving birth was the mother supposed to ask questions? And what would that conversation be?
Well, I think there are
Like, is she supposed to walk out?
there's multiple answers to that, Your Honor, and I think the case law provides for that. We have the situation where she's first provided seeking care and treatment, you get the notice, okay? Then you come in, you get notice again. There are parts of the statute that speak to emergency situations, which is not here, but I think the case law and the legislature have addressed when is this supposed to happen. It's supposed to happen when it's reasonably practicable, and that's what happened here. She came in on the date of birth, was given the form again, was given the notice, was given the brochure, and that's clear in the record.
What is the purpose of the notice, in your view?
The purpose of?
The notice, yeah.
Purpose of what notice? The
The
brochure
notices
or
we're talking about.
signing the notice form?
Any of the notices.
The purpose of signing the notice form is to say, I've received the information, I have asked no questions, I'm signing that I received this information, so that later I can't make a self-serving comment to say, I didn't get it.
Well, that's a legal effect, but what do you think, as a policy matter, what is the purpose of providing a patient notice?
The
about this
notice
whole
form?
system? Yeah.
To be able to allow for the rebuttable presumption.
No, that is, again, a legal answer. What is as a policy matter, why is there an expectation that a patient receive notice about this entire system?
I'm sorry, I couldn't hear the question.
What do you think the policy is, the purpose behind expecting a patient to get notice before your clients can get immunity under the statute?
The policy reason is to allow my client the protections afforded by NICA.
Okay, so you don't think, so for you, it's just a box-checking exercise. There's really actually no substantive purpose behind having the patient get notice.
No, I don't think it's a box-checking exercise, because again, there's case law that says that doctors can or cannot have them sign a form. I think it's something that establishes and allows clients like mine that extra afforded protection of going in and saying everything was done properly, everything that NICA and the legislature has said do has been done, and now this is going to prohibit someone from coming in later saying, I didn't know about NICA, I didn't understand, when you have a document that says exactly what you did.
Isn't the idea that a patient might have a choice? So, okay, well, you're a NICA doctor or NICA doctor. I'm going to go to someone that isn't going to claim immunity if something goes wrong, right?
Right.
Isn't that possibly an explanation for the policy?
That could be it too.
Right.
Absolutely.
So is it relevant or not relevant, when they're talking about practical, is it relevant, the circumstances under which the notice is provided?
In this case, or in any case?
Actually.
I think factually depends on the case. I think it depends on whether you're talking about a situation where the patient comes in at the beginning of her pregnancy and is provided with the information. I think it depends on the circumstances of which the patient presents to the hospital, whether it's an emergency or not. It just really depends factually on the patient.
Is it relevant whether the patient has the opportunity to just walk out and then go find another doctor that?
That's the whole purpose of telling them about NICA. They can go and when they start their care and treatment, they're told that I'm a NICA provider. I don't want the NICA provider. I'm going to go find someone else. Your patients are absolutely allowed to do that whenever they so choose. But if they sign the form, they acknowledge that NICA, this doctor is a NICA doctor.
So it's your position that if they sign the form in advance, you're basically accepting the risk that you show up at the hospital to give birth, and it may be a doctor that is a NICA provider.
Well,
It may not be, but
it would be.
likely would be, and
What-
you're on notice.
Once you sign that form, you're on notice. All physicians from USF are NICA physicians. And counsel's arguments about the form and what's contained and the names and all that, it has all-encompassing language. Would it have been better if all of the doctors were listed? I'm not going to sit here and tell you it wouldn't be. Okay, but the fact remains that we have all-encompassing language, all USF physicians. Counsel's attacking something that was read by the patient and signed by the patient that she acknowledged. USF was a physician under NICA. There was the group, all physicians. What we're looking at here is a form that, again, not signed once, signed twice. There's no evidence in the record that the patient had any questions about any of this. It was signed, and that's what provides USF with the protections that NICA affords.
So you agree that the claim otherwise would have been compensable? Like your client concedes that the injury qualifies under the statute?
That is what the ALJ found.
I didn't ask what the ALJ found. I asked whether your client concedes that is accurate.
I believe so, yes. And with that, if there are no further questions, I'm going to hand the floor to counsel for NICA. Thank you, Your Honor.
Thank
We
you.
ask that the ALJ's order be affirmed on all grounds. Thank you.
Thank you.
May it please the court, I'm Tana Story, here on behalf of NICA. There have been all sorts of questions asked, and I'm not quite sure where to start, but I will go to the notice issue that you were just speaking of regarding the purpose of the notice. The purpose
Well,
is...
NICA is actually the one common denominator in all these cases. I'm curious, does NICA want to address, since it's a statutorily created entity, why we're even here talking about the ALJ's determination if the ALJ determined that the claim was time-barred?
Yes, I was going to segue into there, but I'll go there. The purpose of, the reason why we're here, when the ALJ says the claim is time-barred, he still has to determine compensability.
Why?
Because NICA was established as an alternative exclusive remedy that would preclude a circuit court action if a claim is compensable and the proper notice was given. If the ALJ is not afforded the opportunity to make that determination that the claim is compensable, anybody could afford the exclusive remedy by waiting 5 years, past the statute of limitations, and then go in circuit court and say, oh, it's not compensable because it would have been time-barred.
And then litigate the very question that we're talking about here and have an Article 5 judge make that determination, right? I mean, NICA is essentially in the executive branch. Would you concede that?
Yes, I would concede
Okay.
that. But
So the ALJ, also in the executive branch, has made a factual determination that apparently may be relevant to NICA or NICA, but how is it relevant outside y'all's branch?
Well, with respect to the notice issue, notice is particular to NICA. That is not something that was in common law and a circuit court judge would typically determine. Compensability is also particular to NICA. Whether a claim is compensable under a plan is purely within the ALJ's jurisdiction. It's been established over and over again by the courts, most recently by the Florida Supreme Court in 2010, and earlier than that, 2007, where that court specifically addressed the jurisdiction of the ALJ to determine notice. The Florida Supreme Court cited this court's determination in tab with approval that the ALJ has the exclusive jurisdiction as of 1998, and most certainly as of 2006, to determine not only notice, but compensability.
Exclusive to whom? So you agree, I guess you're taking the position as your colleagues have, that exclusive means exclusive to the judicial branch. Is that accurate? When it says exclusive jurisdiction in the statute, you're reading that to mean exclusive to the branch that actually does, like, adjudicating that have legal consequences on parties.
It's the exclusive jurisdiction vested within the administrative law judge to make factual determinations. The effect of that on an entity or a person's legal remedies in circuit court is for the circuit court to decide if it happens to go back there.
So if we affirm the order, what effect does that have down the road? Does it have any legal effect at that
If
point?
you affirm the order on all points, including notice, then they could go to circuit court and assert the willful and wanton exception, which would root out any of this conversation. But they would go to circuit court, and the determination of the circuit court at that point would be the effect of the compensability determination and notice, which would be that it's barred because it's an alternative exclusive remedy, which has been approved by the Florida Supreme Court as not violating access to courts and as being constitutional.
Thank you, counsel. And add a minute to the rebuttal time.
Judge Tannenbaum, the purpose is in the Gallen decision. The Florida Supreme Court said it's informed choice, and that's the purpose behind it. They said it was, the notice requirement is justified on fairness grounds. It's my client's constitutional right to a trial by jury, and if she's going to be precluded from receiving that, then she is deserving of the notice requirements. They weren't followed in this case, and we do ask that you reverse and remand, because Judge Lewis, you answered Judge Tannenbaum's question with a question to counsel, and it is a res judicata effect. That is the concern, that if this court affirmed without writing on the notice issue that I would be precluded in circuit civil on the grounds of res judicata. So that is the answer. My client is in a Scylla and Charybdis position based upon the findings of the ALJ. I would note that the tipsy coachman, I know this court has the ability to rule that hasn't been raised until the oral argument. Judge Tannenbaum, I would ask that if this court is not inclined to reverse on the notice issues that we have briefed, on the issue that my client is deserving of the compliance by the appellees of the notice requirements, then I would ask for supplemental jurisdictional briefing as this court's ordered in another case.
Counsel, assume for the sake of argument that we were inclined to reverse on the notice issue. Give us some guidelines or instructions as to how that will proceed.
Thank you. Neither Dr. Brown nor USF, on behalf of Dr. Brown, complied with the plain language, the clear and unambiguous language of 766.316. Neither provided notice to my client that Dr. Brown was a NICA participant, and the statute says each. It says each hospital and each participating physician. As a matter of law, and this court reviews it by de novo, as a matter of law, this claim is not compensable under NICA because there was no valid notice given to my client.
Why wasn't the catch-all phrase in the NICA form sufficient notice under the statute as to Dr. Brown as well?
Because the statute does not say that you can say including but not limited to, or all physicians. It says each. Each must have meaning. the Florida Supreme Court follows a supremacy in text principle. And so the Florida legislature knew what it was writing when it wrote each hospital and conjunctive, and each participating physician. This court cannot take the invitation by appellees to rewrite 766.316. And we ask that you reverse and remand for vacatur of that order. Thank you.
Thank you, counsel. We are in recess.
All rise.
Such a privilege to be here and meet you all and spend the morning with you. Please have a safe travel back.
Thank you. You as well.
It was nice to meet you, ladies.